I welcome you in my 13th lecture relating to legal compliance for incorporating startup. I am in the module called Incorporation of One Person Company, Private Limited Company and Public Limited Company. In my last lecture, I have talked with you regarding Private Limited Company, and in this lecture, I will concentrate more on Public Limited Company. Now, as I have told you before that all these particular companies, either it is a one person company or a private limited company or a public limited company, are governed by one single act, that is called Companies Act 2013. Previously, it used to govern by Companies Act 1956, and the new act has been adopted in 2013, and after that all the companies governed by this particular act. Now, the formalities relating to the incorporation of all the companies are almost same, which I have told you before, and let me take you through some of the characteristic difference which we find in case of public company in compared to the private company. Now, public company are those company which are not a private company, and in case of a public company there can be a specific authorized capital which is different from a private company. Now, previously statute used to specify that what should be the minimum capital with which public company or private company need to incorporate it, but now this particular provision has been withdrawn and it is mentioned in the statute that whatever has been prescribed. That means prescribed through the rules or under this particular Companies Act itself. Now, there might be certain objective because people because government might be interested to incorporate some specific type of organization for a particular sector. So, they might prescribe some kind of entry norms through the authorized capital or the minimum capital with which company can incorporate, and that is the reason possibly they have taken out from the statute book itself. For the formation of a public limited company, you need to have a 7 member. In contrast, private limited company, you need to have only 2 member. In case of a public limited company, you need to insert the word limited in the name of a public limited company. At the same time, the public limited company can issue the shares or can freely transfer the shares, which is characteristically different from the private limited company, because in case of private limited company you can have a restriction, but in case of a public limited company it need to be freely transferable. Now, again the public limited company can be similar nature as we have in case of a private limited company. So, public limited company can be limited by share, public limited company can be limited by guarantee, and public limited company can be unlimited or public unlimited company. If it is an unlimited company, then in that case the word limited will not be used in the name of a public company, and at the same time public company may be listed and unlisted. Now, I am not going to explain these other 3 category, that is limited by share, limited by guarantee or unlimited, because I have already done that in my last lecture when I was talking with you relating public private limited company, and it is almost the same. Only thing I like to draw your attention, it is very uncommon to have a public limited company by the guarantee and public unlimited company, or public limited company with a share as well as guarantee. So, most popular form of public company which you will find in the market are public limited company, public company limited by shares. Now, Public limited company or public company limited by shares can be again divided into a two broad category. One is known as a listed company, another known as unlisted company. Now, unlisted companies are those companies whose shares are or securities are not listed in a stock exchange. Now, what is a stock exchange? Stock exchange is a market where you trade the securities of the company. Now, when I am using the word securities, it means that any kind of instrument which company issue for raising the capital. So, it can be shares, different kind of shares, it can be the debenture, it can be the bonds, it can be the deposit, so much so forth. Now, previously a particular type of the shares can be listed in a stock exchange, that is the equity share can be listed in a stock exchange, and other kind of securities was not allowed to be listed in a stock exchange. But today you will find there is a all kind of security or most of the kind of securities are listed in a stock exchange, so that it can give the subscriber a better liquidity into in their investment. And there is a several law applies for that. I am going to talk on that in subsequent part of my lecture. Now, when we are talking about the unlisted company, the securities of this public company limited by the shares are not listed in any stock exchange, but these particular companies can raise the money from the public. That means, they can go for a private placement to raise the money, or they can even raise the money from the primary market by other means. They can even raise the money from qualified institutional buyer. So, there is a many way you can raise this particular money. Now, again the registration process in case of a public limited company are same as a private limited company. So, I am not repeating those particular thing. Again, in case of a public limited company, you need to find out the name, register office, you need to talk about the authorized capital, then you need to talk about constitution and the formation document of a public limited company, and then you need to talk about the incorporation certificate. Now, these provisions are almost same with a private limited company. So, I am just avoiding repeating this particular thing with you. Now, there is a few significant point which you should keep in mind if you are incorporating your startup as a public limited company. In case of a public limited company, the compliance requirement is more stringent or very stringent in compared to all other formal form of business. So, the highest compliance requirement is with a public limited company, and if it is a public listed company, then compliance is much more. So, to put it in other way around, the public companies are subjected to several law apart from the Companies Act. So, you might be governed by the security laws, you might be governed by some laws which is prevalent in money market, you might be governed by the laws which is relating to the foreign exchange, direct foreign policy. You might be subject to the bilateral treaties, you might be subjected to multilateral treaties, you might be subjected to any investment directives by any international agencies. So, it is quite complex. Now, it is also complex relating to accessing the capital into the different market. I am going to talk with you a little later relating to the accessing of the capital. And in case of the public company, it is not only access the capital from the domestic market, but they can even go to the overseas market or the foreign market to raise the capital for their company. So, if you have an appetite to grow very high, or if you think that a particular sector where you are entering into the business, the composition of the market is such that you need to have a quick growth and you wanted to be a large company, then it is advisable that you should start your business as a public limited company. But as I told you, the incorporation of a public limited company is a costly affair. At the same time, compliance which you need to carry forward during the business of the public limited company is much higher in compared to any other form of the business. Now, in case of the public limited company, this is in the recent year, if you look into the directives from Security Exchange Board of India, SEBI, then you will find that all the securities which is issued by a public limited company should be in a dematted form. That means, you cannot issue the shares today in a physical paper form, physical form or printed in the paper, or you cannot issue the debenture printed in the paper. So, you need to enter into contract with the depository, and then the depository is going to hold the shares which you are issuing for the benefit of the subscriber through their depository participant. Now, who is the depository? Depository again another company who is authorized by the regulator to act as a custodian of the shares or the securities. So, this is another complex process and this is also cost intensive. So, if you want to incorporate as a public listed company, then in that case again you have to go with the depositories. Now, next important thing is that whenever you are issuing the securities for a public company, you need to go for you need to enter you enter into a listing agreement with the stock exchanges, and according to the law you need to enter into a at least two agreement with at least two stock exchange. One is with a national stock exchange, another is a regional stock exchange. So, again listing the securities is a costly affair. So, all this particular thing if you take together, then in that case is really a costly affair from the part of the compliance. So, generally whatever the people take the strategy, people incorporate a startup as a private company, and then when they found that they have a more appetite for the fund or for the capital, and they wanted to aggressively expand that particular company, then they generally convert their business from private company to a public company. But you will find still until people are compelled to do that for their growth, they try to keep that particular company as a private company only. Like in between, you must have heard that the Flipkart, they wanted to go for a public offer, but later we found that there is a sort of news in the media that they have got a further investment from the private equities, and they for the time being they have not converted their company from private limited to public limited. So, it is a part of the strategy also that how you wanted to carry forward your business and what is the requirement of that particular segment you are entering as a startup. Now, as I have talked with you that if you are incorporating your startup as a public listed company, then the security which you are issuing to the people, that can be traded in a stock exchange. And when I am talking about the securities, I am talking about all kind of instrument, either it can be share, it can be debenture, it can be bonds, it can be other kind of convertible securities like convertible debentures, so much so forth, that can be traded into the stock exchange. Now, there is a very interesting thing in case of a public listed company or public unlisted company, and that is the reason public listed or unlisted companies are always a preferred vehicle when you wanted to address the growth or you wanted to grow quite faster. Because in case of a public listed company, accessing the capital is comparatively easy than in any other business form. because you need to do a lot of compliance, you have to maintain a lot of transparency, you need to structure the information relating to your organization. So, that actually gives you a better credibility to those people who want to make an investment in the company. So, in case of a public listed company, you can issue the shares with your existing shareholders through the means of a right or bonus issue. You can go through the public private placement. That means you can address to the target people to raise the fund. You can also access to the primary market. Primary market means inviting the public subscription. That means you can invite the public to subscribe your securities. So, that is generally commonly known as a primary market, and you can also go to the foreign market through your issuing of the depository receipt. Now, you will find there is a 3 common depository receipt generally prevailed in the market today, that is American depository receipt, second is global depository receipt, and third one is Indian depository receipt. So, through this any of this instrument, any of this particular pattern, you can access the market. But apart from that, you can also raise the money from the any public financial institution too. And most of the time, you will find the public financial institutions are the biggest investor in the capital of or in the security of a public listed company, because they also get benefit by the market capitalization. That means, increase in the value of the shares of the company in a stock market, at the same time from the dividend which this particular public listed company provides to these public financial institutions. So, if you are incorporating your startup as a public listed company, you have a lot of option to raise the capital from the different sources. Now, whenever you are going for accessing the market, we commonly talk about raising the fund or issuing the security is accessing the market. There is a lot of restriction which you are subjected to while you are accessing the market. And please note that you cannot yourself do this particular thing by your own. You need to appoint the expert intermediaries who have been licensed by the regulators in that particular market. Like if it is a capital market, then that particular person need to be licensed by the capital market regulator, and if that particular Now, most important thing which you need to do whenever you wanted to access the market is to prepare an offer document, which is commonly known as prospectus. And there is a different stages of preparation of this particular offer document, and these particular offer documents are generally prepared by these intermediaries, which is commonly known as a merchant banker. And there is a number of other intermediaries who support the merchant banker in accessing the market or carry forward the issues, either it is the initial public offer or follow up public offer. They are the lead manager, banker to issue, registered to issue, underwriter, so much so forth. And this is a complex process, and this particular process you need to carry forward if you wanted to access the market and raise your capital. Now, let me take you to the next issue relating to the compliance. In case of the compliance also of a public limited company is quite stringent in compared to private limited company. So, you need to hold an annual general meeting periodically and in a manner it has been prescribed in this particular act itself. Before you hold the meeting, you need to give all the information which is required to be given to all the members, like you need to provide the annual report, you need to provide the financial statement, which is audited financial statement. Then you need to provide the director's report, and in the director's report there is almost everything relating to company is need to specify. So, you need to specify relating to what are the capital condition of that particular company, how much what are the type of business company is carrying, what are the risks which is involved into that particular business, what are the measures you have taken to manage this particular business risks, then what are your corporate governance initiation within your company itself, then how you make the decision relating to the business policy and the management of the organization, what are the committees through which you function the board. So, all these particular details you need to provide in the annual general meeting, and in the annual general meeting all the people who are the member of the company need to be called, and again you need to give a 21 days notice, and this particular annual general meeting need to be held in the registrar office of the company, and it should be done from 9 a.m. to 6 p.m. of any working days. So, in case of the annual general meeting, as I have discussed with you relating to the notice of the meeting, in the notice of the meeting you need to annex the annual report as well as the financial report, and you need to give this particular notice 21 days before this particular annual general meeting. So, there should be a quorum in the meeting, and the quorum should be specified in the AOA of the company. The chairman of the meeting, as I have told you, that generally the chairman, same person who act as the chairman of the board, is generally the chairman of the meeting also, and you will find nowadays this particular chairman is became almost a permanent post. So, chairman of the company, though it is not statutorily required, but chairman of the company is almost became every company maintains that, and the same person chair as in the board meeting as well as in the general meeting of the company. Then you need to give allow the proxies to come in, and in case of a public limited company, the proxy importance of the proxies are very high. Like in our country it is developing, but in other country you will find there is a proxy statement, there is a foundation of a voting trust which is managed by the proxies, because in case of a public limited company it is widespread shareholding. So, it is not possible for many shareholders to come and participate in person. So, they generally appoint the proxies to go and vote on their behalf, and similarly statute as well as the good governance principles are prescribing that we should more and more emphasize on the postal ballot. Whenever I am talking about the postal ballot, which I have explained to you in my last lecture also, we are talking about all the electronic mode through which people can participate in the voting on the issues of the company. Now, I have already talked with you relating to this aspect of the board, but nevertheless let me put it some structured information. In case of a public limited company, there should be a 3 member in the board. So, minimum member should be 3. The first board meeting should be within the 30 days of the incorporation, and there should be a 4 board meeting. Now, please remember, in case of a public limited company, what the board has been discussed and what the decision has been taken by the board, that need to be recorded, and that should be reported as a part of a corporate governance report. Not only that, as I have talked with you, in case of a public limited company, now law prescribe that there should be a subcommittee in the board, like there need to have a audit committee, there need to have a grievance redressal committee, stakeholder grievance redressal committee, there need to have a succession committee, and there need to have a compensation committee. Apart from that, there can be a number of committee in that particular board. So, what law is prescribed that whenever the board is taking a decision, board is taking a informed decision after giving a adequate time to analyze the situation, and then to decide that what should be the right policy for that particular company. So, these particular process and everything, every meeting of the committee, not only the board, but the subcommittee of the board need to be reported. and what are the matters they have discussed, that also need to be reported. So, it is very stringent process, and you in addition to that, you need to give the qualification of the directors who are became the director of that particular company. Please remember, this disclosure is specified not only in the listing agreement, but it is specified in the statute itself. So, one need to specify this particular information in the annual report itself. Now, in the present statute, you will find they have prescribed the duties for the directors, and this is a new insertion for the public company, which was not there previously. And herein they have basically said that director has a duty not only the company, but for all the stakeholder of this particular company, in addition to the environment where they are operating. So, the public companies directors has a lot of duties. That means, if you are a promoter of the company of your startup, and you have incorporated your company as a public limited company, and you have become a director of the company, be careful about your responsibility, because if you have been infringing this particular positive responsibility which has been given or which has been imposed on you by the statute, then in that circumstances you will be debarred to be a director of your company. So, in case of a public limited company, you have a further responsibility relating not only to your company or to your shareholders, but to all other people who are one or other way around attached with your company. Now, again you will find the statute has prescribed that there should be a corporate social responsibility, and they have specified that which of the company should have the corporate social responsibility, and therein they have applied two criteria. One is a net worth of this particular company, at the same time the turnover of the company. So, there is every possibility that if you are incorporating a startup as a public limited company, then in that circumstances you might come within these particular parameter, and in those circumstances you need to pay 2% of your profit for the purpose of corporate social responsibility. Now, again the power of the board is prescribed under the Companies Act, as I have talked with you in case of a private limited company. There is a certain restriction has been provided, and the restrictions are relating to the restructuring of the board, relating to raising of the further capital, relating to selling of the assets of this particular company, relating to giving the loan to the directors, and so on so forth. But whatever the power which has been provided in case in objective clause of the company, a company will have the similar kind, I mean board of director will have a similar kind of power. Now, the related party transaction is one of the very important issues which has been inserted, which I have talked with you in case of a private limited company, and this is more stringent in case private limited company, and this is more stringent in case of a public limited company. And whatever the related party transaction happen in your company, that need to be reported. So, if any member of your company or any director of the company are interested in a transaction, that means you are purchasing a land from a member of the company or a director of the company, or you are outsourcing some work to a company where the same director also a director in that particular company, or if you are sourcing some of the input material from the organization where from the company where the same directors are the director or the relative of this particular director is a director, then in that case all this particular thing comes within the related party, and whatever it is you need to specify in detail about this particular transaction. Now, issues of the corporate governance are very stringent, and reporting of the corporate governance are become very structured now, and to promote this particular corporate governance there is a several issues has been incorporated now, now there is a the independent directors who should be as a part of the board in a public limited company is been prescribed under the act, and they have also prescribed who can act as an independent director, what should be the qualification of the independent director, and what are the responsibilities of the independent director. Please remember, today the act has given the power to the independent director that they can hold the meeting without the promoter's director or the executive director. So, if you are a promoter director, or if you are a promoter and then become a director, even the independent director can hold the meeting without you and take a decision which is binding on the company. So, these are very stringent provision, very difficult provision. Now, there is a issues relating to the corporate insolvency in case of public limited company, and you need to address that. That means, there might be scenario where you might have a prospect of the business, but all of a sudden there is a crunch relating to the liquidity, or you have lost a lot of money in a particular business because of the external condition which is beyond your control. Then you might face the insolvency scenario, and if you are become insolvent, then there is a several ways by which you can come out of that particular scenario, and you will find that the government of India now passing a bill relating to the corporate as well as individual insolvency or business insolvency, and possibly that might be the law after some days. Then there might be a situation relating to the substantial takeover, substantial acquisition and the takeover. And in case of public limited company, there is a possibility to have a market takeover. That means, some other company can purchase the shares of yours from the market, and then they can take the control over your company. So, this particular scenario only can happen in case of public limited company, public limited listed company. It is not possible in other company. So, if you do want to hold your company back with yourself, then you need to have adequate measures to stop this market acquisition. Similarly, there is a possibility to have a merger, there is a possibility to have a further acquisition by some other company, which is basically known as a share sale agreement or some other process. It can be done, or there can be a spin off in your company. That means, some of your undertaking might become independent than your company, and they can be a subsidiary of your company, or they can be a form of your group company. And at the same time, there is a possibility that if your venture is not going well, then you can wind up your company by following the process. So, there is a two type of winding up is possible. One is by the court, and another is a voluntary. So, whatever you do in these particular circumstances, board has to take a decision, and then in that case you need to have an expert to help you out to take you through this particular process. But please remember, the government of India is trying to smoothen this particular process of incorporation, at the same time to exit this particular process, because India is not very friendly to the business incorporation in compared to other country. So, the present government is trying hard, so that you can incorporate your business quickly, and if you are not able to run your business nicely, then in that case you can quickly exit out of your business. So, if you are thinking that you will incorporate your startup as a public limited company, then I think you need to give a serious thought before you do that, because it is a money intensive, it is a compliance intensive, and it may be the difficult form to choose in the beginning of your startup. Thank you.